Very warm good evening to all. Today we will be discussing two topics from the Civil Procedure Code. Now, Civil Procedure Code is again a very vast subject. If you go on reading it, it will give you an idea and understanding that the complete civil procedure of the civil codes is governed by the Civil Procedure Code, and this civil procedure is completely telling you what is the procedure to be adopted, and it to have an idea to understand from the subordinate civil code to the Supreme Court, everything is mentioned in that, how the cases will be transferred, how the matters will be handled, how the evidence has to be laid. That is about the Civil Procedure Code. Today we will be looking at two very important sections which all the lawyers has to know, and compulsorily those who are practicing the High Court and Supreme Court and otherwise also. This is section 24 and section 25 of the Civil Procedure Code. Now let's see what is section 24. Now here when we see section 24, just a minute. General power of transfer and withdrawal. On the application of any of the parties, after notice to parties and after hearing such of them as desired to be heard and or of its own motion, without such notice, the High Court or the District Court may at any stage. So this is very important. General power about transfer and withdrawal. Now withdrawal does not mean here case withdrawal from one court to the and given it to the another court. That is the meaning of withdrawal here. Always remember, this is not a withdrawal of the case. हमने वहां से withdraw कर लिया घर चले गए. It's not like that. Withdrawal from one court and given it to another court, and general power of transfer. Now this is section 24 is regarding High Court or the District Court may at any stage transfer any suit, appeal or other proceeding, any proceeding for that matter, pending before it for trial or its disposal to any court subordinate to it. High Court, District Court दोनों के लिए लागू होगा, and competent to try or dispose of the same or withdraw any suit. पहला आया transfer A के लिए, B is for withdraw any suit, appeal or other proceeding pending in any court subordinate to it. उससे जो lower court है वहां से subordinate है, उससे छोटा court है, and try or dispose of the same, खुद ही try or dispose of कर दे, or transfer the same for trial or disposal to any court subordinate to it. वो दूसरे court को भी भेज सकता है. इसमें हाई कोर्ट और डिस्ट्रिक्ट कोर्ट दोनों शामिल है. So let's understand कि हाई कोर्ट has a power here for us to simplify the same and competent to try and dispose of the same or retransfer the same for trial or disposal of to the court from which it was withdrawn. हो सकता है उसी को retransfer कर दे जिसने जहां से कोर्ट केस withdraw किया है. Where any suit or proceeding has been transferred or withdrawn under subsection 1, the court which is thereafter to try or dispose of such suit or proceeding may subject to any special directions in the case of an order of transfer, either retry it or proceed from the point at which it was transferred or withdrawn. For the purpose of this section, courts of additional assistant judge shall be deemed to be subordinate to the district court. Proceeding includes the proceeding for the execution of a decree order as well. मतलब execution भी हो सकता है, जरूरी नहीं कि वो trial ही चले. The court may trying any suit transfer or withdrawn under this section from a court of small cause court shall for the purpose of such suit be deemed to be include to be a court of small causes court. A suit or proceeding may be transferred under this section from a court which has no jurisdiction to try it. Now to understand section 24 in a very simple way is that district court and high court. Suppose let's take it the High Court, and there are two district court in Mumbai. That is, one is at Mumbai and another is at Thane Court. Now there is a matter which was going on in the Thane Court, and for some reason you want to transfer that to the Mumbai District Court from Thane. Thane is another district here, Mumbai is another district. Those are from outside. I want to tell them. Now from another district to this district court, if you have to transfer, now these powers are given to the subjective state government High Court, that is the Bombay High Court here. Okay. So in from here in Bombay High Court, what will happen? You have to go for a transfer petition, and you have to tell the reason why you want to get a transfer. There may be 100 reasons, there may be one reason, but then you have to make out a case for transfer. It may be an appeal, it may be a divorce petition. Suppose there is a divorce petition in Thane and you want to get it transferred to the Nagpur, then you can approach the Bombay High Court here. And now here is the simultaneously, even Nagpur bench will also have a jurisdiction, because if there is the lady client is staying in the Nagpur, then she will be filing before the Nagpur. So understand that the Bombay High Court jurisdiction is all over Maharashtra. Now suppose there is a divorce petition, which is civil matter under section now 24. You want to get it transferred to the, your lady client is at Nagpur, and your one husband has filed a case in the Thane, and you want to get it transferred to the Nagpur. Then you have to approach the Bombay High Court and make out a case that she has a children and she cannot travel. That is how the Bombay High Court you can convince and can get the matter transferred to the Nagpur Family Court. It is that simple. Now next we go to the section 25. This is also similar, only the powers are with the Supreme Court. Power of Supreme Court to transfer suits, etc. on the application of a party and after notice to the parties and after hearing such of them as desired to be heard. The Supreme Court may at any stage कोई भी हो सकती है, if satisfied that an order under this section is expedient, मतलब expedient for the ends of justice, न्याय के लिए जरूरी है, direct that any suit, appeal or other proceeding be transferred from a high court or other civil court in one state to the high court or other civil court in another state. See, understand the difference between. Suppose there is a matter pending before the any of the high court, or suppose there is a matter pending before the Bombay Family Court or in the Bombay High Court, and you want to get it transferred. If there is a writ petition which you want to get transferred to another high court, then also you have to approach Supreme Court, because one high court's powers and another high court's powers are at equal level. So it is not possible that one high court may you can direct the another high court. So if their powers are equal, it cannot. Another reason, these are two different states. So matter between the two states will always go to the Supreme Court. I'll give you a simple example first to make you understand that again a very there is a maintenance petition, or there is a maintenance of course by lady, so it is really difficult. Again a husband files a divorce petition in the Mumbai, that is Mumbai Family Court, and the wife against the wife, and she is residing at, suppose at the Panipat or Haryana. Now this Panipat, Haryana, these will come under the jurisdiction of Punjab and Haryana High Court. Now Punjab and Haryana High Court is a different court, High Court. Bombay, it is a different High Court, Bombay High Court. We are governed by Bombay High Court. And at Panipat, that lady will be governed by the Punjab and Haryana High Court. Now Punjab and Haryana High Court cannot ask Bombay High Court to transfer this case of Mumbai Family Court to us. So in those cases where the matter is between the two states, or matter is pending in one state, that is in Bombay High Court, in the Maharashtra, and you want to get it transferred to the Haryana, then you have to approach the Supreme Court, because there are two states involved. Always remember that if there are two states involved, then you have to always approach the Supreme Court. If there is one matter which is pending in one court in the jurisdiction of the Maharashtra, and another is at the Haryana, Punjab, or somewhere else, Delhi, or in a Bangalore, then you have to always approach the Supreme Court, because the one state government cannot even direct, or one Bombay High Court cannot direct, the High Court cannot direct the another High Court that transfer this matter to us, unless it willingly does it. So always remember if there is a divorce petition pending in the Mumbai Family Court or any of the at Raigad, Palghar, anywhere, and you want to get it transferred to the Delhi, then you have to approach the Supreme Court. That this is section 25. This is called transfer petition. So it is actually very simple. Only you have to read. Always remember for the High Court this section 24 and for the Supreme Court is section 25, and it may be any appeal, it may be any civil suit, it may be any decree, execution orders, any kind of proceeding can be done it. For criminal it is different. For civil, these are the two important sections. So now let's go to Sayantika for reading. Sayantika, unmute yourself. Just a minute. Sayantika is going to read very important thing today. It is about the furlough and not a legal right. Supreme Court explains difference between parole and the furlough. Now let me tell you, parole and furlough is a kind of leave which a person who is convicted and is in jail, he gets it. The person who goes as a temporary for once arrested and there is he is applied for bail application, all that, he will not get it. The person who has been convicted, whose matter has been tried completely by the trial court, and he has been convicted because of any offense, maybe rape, murder, or any small accident cases also. These are the leave which a convict gets, prisoners gets. Although furlough can be claimed without a reason, the prisoner does not have an absolute legal right to claim furlough. Now I'll ask Sayantika to read. Sayantika, start reading from here.
The bench of Justice Dr. D.Y. Chandrachud and B.V. Nakaratna has formulated broad general principles governing rules for granting parole and furlough, holding that parole and furlough are distinct in nature, and although furlough can be claimed without a reason, the prisoner does not have an absolute legal right to claim furlough. Interpreting the Bombay Furlough and Parole Rules made pursuant to Section 59 of the Prisons Act 1894, the court noticed that the same do not confer a legal right on a prisoner to be released on furlough. The grant of furlough is regulated by Rule 3 and Rule 4. While Rule 3 provides the eligibility criteria for grant of furlough for prisoners serving different lengths of imprisonment, Rule 4 imposes limitations. The use of expression may be released in Rule 3 indicates the absence of an absolute right. This is further emphasized in Rule 17, which states that the rules do not confer a legal right on a prisoner to claim release on furlough. Thus, the grant of release on furlough is a discretionary remedy circumscribed by Rules 3 and 4 extracted above. The principles laid down by the court are furlough and parole envisage a short-term temporary release from custody, while parole is granted for a prisoner.
Wait. Read little slowly. Now here I would like to say, these principles laid down by this court. Everybody here, please kindly pay attention. She's reading a very important piece. Furlough and parole, and we say the short-term temporary release from custody of the prisoner. Start reading.
While parole is granted for the prisoner to meet a specific exigency, furlough may be granted after a stipulated number of years have been served without any reason. The grant of furlough is to break the monotony of imprisonment and to enable the convict to maintain continuity with the family life and integration with society. Although furlough can be claimed without a reason, the prisoner does not have an absolute legal right to claim furlough. The grant of furlough must be balanced against public interest and can be refused to certain categories of prisoners. Important rulings on the difference between furlough and parole. State of Maharashtra versus Suresh Pandurang Darwakar. While both parole and furlough are temporary releases from confinement, parole is granted only for a specific purpose. A prisoner is entitled to apply for furlough once he has served the minimum years of sentence as stipulated in Rule 3. The furlough and parole have two different purposes. It is not necessary to state the reason while releasing the prisoner on furlough, but in case of parole, reasons are to be indicated in terms of Rule 19. But release on furlough can be said to be an absolute right of the prisoner as culled out from Rule 17. It is subjected to condition mentioned in Rules 4 and 6. Furlough is allowed periodically under Rule 3, irrespective of any particular reason, merely with a view to enable the prisoner to have a family association, family and social ties, and to avoid ill effect of continuous prison life. Period of furlough is treated as a period spent in the prison, but Rule 20 shows that period spent on parole is not counted as remission of sentence. Since the furlough is granted for no particular reason, it can be denied in the interest of society, whereas parole is granted only on sufficient cause being shown. In state of Haryana versus Mohinder Singh, when a prisoner is on parole, his period of release does not count towards the total period of sentence. While when he is on furlough, he is eligible to have the period of release counted towards the total period of the sentence undergone by him. As Park versus State of Rajasthan, a parole can be defined as conditional release of prisoners, that is, an early release of a prisoner conditional on good behavior and regular reporting of authorities for a set period of time. It can also be defined as a form of conditional pardon by which the convict is released before the expiration of his term. Thus, the parole is granted for good behavior on the condition that parolee regularly reports to the supervising officer for a specified period. Such a release of the prisoner on parole can be temporarily on some basic grounds. In the eventuality, it is to be treated as mere suspension of the sentence for time being, keeping the quantum of sentence intact. Release on parole is designed to afford some relief to the prisoner in certain specified exigencies. Furlough, on the other hand, is a brief release from the prison. It is a conditional and is given in case of long-term imprisonment. The period of sentence paid on furlough by the prisoners need not be undergone by him as is done in case of parole. Furlough is granted as a good conduct remission. Key differences highlighted in the judgment are both parole and furlough are conditional release. Parole can be granted in case of short-term imprisonment, whereas in deputy inspector, parole is granted by divisional commissioner and furlough is granted by the Deputy Inspector General of Prisons. For parole, specific reason is required, whereas furlough is meant for breaking the monotony of imprisonment. The term of imprisonment is not included in the computation of the term of parole, whereas it is vice versa in furlough. Parole can be granted number of times where there is limitation in the case of whereas there is limitation in the case of furlough. Since furlough is not granted for any particular reason, it can be denied in the interest of the society. State of Gujarat versus Narayana.
Thank you so much. To let's elaborate a little bit, it is a very important part about Sayantika read today. See, parole is actually suspension of a sentence. Suppose you are given 10 days parole because your mother is sick, that convict's mother is sick, the person who is convicted, जो prisoner होता है, उसकी mother बीमार है या फिर उसकी family में कोई शादी है या there is some reason, some emergency, then parole is granted. And for that, application has to be made to the competent authority, prison authorities. And then if it is rejected, then you always go to the High Court. And if High Court feels it right, they may grant you the parole. So parole is actually a suspension. Now, if you go 10 days outside, then you come, then you have to complete those 10 days whenever your conviction period is not reduced. But furlough leave is different. In furlough leave, actually it is your, sometime it is your legal right. Though the word in the Maharashtra prison rule is used may be granted, but normally furlough leave is like after 6 months is granted. Sometimes it is granted after every year. That is after those who are convicted for a long time. But then if you are released on furlough leave, those leaves are counted as actually have gone. If you are go outside for furlough leave for 10 days or 20 days in a year, these 20 days will not will actually be reduced from your regular this conviction period. It will not be counted. But in parole, when you come back, these 20 days when you go out, these 20 days will be counted and you have to continue. So it is not suspended. It is suspended in the case of the parole, but it is not suspended in the case of the furlough leave. And furlough leave, it is remission. Once you are out means out. And this, even if you are outside with your family and you are convicted, you are outside with the family on furlough leave. So what happens? Even if you go outside for 10 days or 20 days, this will be counted and it will be remission कि आपको छूट दे दी गई भले आप आपकी फैमिली के साथ रहो. तो पर्पस जो है परोल का और फरलो का कि मोस्टली वो सोसाइटी में वो आता जाता रहे. Suppose there is a convict person, prisoner, who is convicted when his children were 2 years old, and if he is convicted for 10 years, and if he returns after 10 years, his children will be 12 years, so he will never have any family ties. अच्छा, वंस कन्विक्ट, एक बार कोई आदमी दोषी पाया गया तो ऐसा तो नहीं कि वो हमेशा ही दोषी आरोपी रहेगा. तो जो न्याय है, जो कोर्ट है, वो ये सोचता है, जो हमारा लॉ है वो ये सोचता है कि दिस पीपल ऑल्सो डिजर्व सेकेंड चांस. So when they come back to the society, they can be adjusted. If a person goes inside for 10 years and he doesn't come back at all, so it will be very difficult for the families also. So always remember here that what happens that in these leaves are granted to these people, prisoners, only that they can continue with the society, with the same society. They can come and go back and they can take care of their families. They can make some arrangements. Suppose there is shop, maybe there is a something which important है, उसके parents बीमार है, तो उसको ये सारी चीजों का थोड़ा सा उसको हेल्प करने के लिए और उसका फैमिली सोसाइटल टाइज टूटे नहीं. दैट इज द रीजन. तो इन क्रिमिनल मैटर्स अगर आपके एक्यूज को सजा लग गई तो मैटर वहां खत्म नहीं हुआ है. एक्चुअली उसके बाद भी बहुत सारी चीजें, इनफैक्ट प्रोबेशन ऑफ ऑफेंडर्स एक्ट भी है, बहुत सारी चीजें है, रेमिशंस है. आप राष्ट्रपति से, गवर्नर से उसकी छुट्टी के लिए भी अर्जी कर सकते हो, उसकी सजा माफ करने के लिए भी अर्जी कर सकते हो. There is a mercy petition also which you must have read in newspapers. So there in criminal practice there is no end. So thank you Sayantika for reading the beautiful piece and enlightening all of us. Now we'll go to the legal vocabulary. The first word is facilitate. Now facilitate मतलब easily available करा देना. The respondent behaved so cruelly in front of the judge with the petitioner. Respondent ने इतना बुरा बर्ताव किया with the petitioner that it facilitate the further belief of the court that the petitioner was actually harassed. कि वो जब कोर्ट में इतना कर रहा है तो उनका कोर्ट का बिलीफ उन्होंने पक्का कर दिया कि वो घर में कितना करता होगा harassment. So facilitate is a different word which we should use. Rapid deployment. Normally rapid deployment is related to the army. The tension at the border was so severe that army was deployed. Or rapid force was deployed. ऐसे हम लोग बोल सकते हैं. I was doing a judgment, so I have taken out few words. Hilly terrains. The hilly terrains, मतलब पहाड़ी इलाका, are areas where it is difficult to dig for railway lines. Therefore, Nepal is one country where mode of air is more popular than road. Hilly terrains होते हैं तो उसको बहुत difficult होता है dig करना railway lines. इसलिए नेपाल में the mode of the air is more popular than road. पहाड़ी इलाका से. Constitution of committee. The welfare committee is constituted to look into the increase in crime against women. The welfare committee is made नहीं बोलते, welfare committee is constituted. Conformity, the application is in conformity with the order issued by this court. इस कोर्ट ने जो भी ऑर्डर दिया है उसी के अनुसार एप्लीकेशन बनाई गई है. Simple words, but then we have to use this. Narrow variance. There has been a narrow variance. Variance मतलब बदलाव या changes in the petitioner's pleadings and argument. Petitioner की जो pleading है और arguments है उसमें there is no variance या there is narrow variance. बहुत ही छोटा सा बदलाव होगा. जो उन्होंने pleading में लिखा है वही उन्होंने arguments में भी कहा है. Peruse, very popular word in legal vocabulary. I have perused the application and found no merit in this case. Normally judges use करते हैं. I perused your application, there is no merit in your case, therefore dismiss. Material change. Now material change is again a very legal vocabulary का काफी popular word है. There is no material change in his behavior even after the court gave admonition to him. Admonition मतलब warning देना. Warning देने के बाद भी भाई साहब के बर्ताव में कोई फर्क नहीं था. There is no material change. Revisionist. Now revisionist one word. Revision आपको पता है उसी का मतलब है. तो जो revision होता है, I have told you review is before same court, revision is before the higher court. Revisionist, तो जो revision करता है उसको revisionist बोलते हैं. Revisionist has got a good case on law point. You can always say कि revisionist जो petitioner है या revision कर रहा है उसका case बहुत अच्छा है law point पे. Erroneously, again a very popular word. The learned judge erroneously passed the order in favor of the respondent. See the language. Learned judge erroneously, गलती से pass the order in favor of the respondent. आप अपील में mostly वाक्य यूज करते हैं. Testimony is deposition. कोर्ट के सामने कहना. The testimony of your client does not inspire confidence. तुम्हारे client ने कोर्ट में जो भी कहा उससे कोई confidence नहीं आता है. Heaped, ढेर लगा देना. The amount of grief heaped inside you will make you emotionally more weak. This is like an emotional sentence which you can use in a matrimonial dispute. Fact of demand. The fact of demand. देखो word तो एकदम normal है. Fact सच्चाई, demand है ना कहने पर. The fact of demand says you should always be clear while asking relief from the court. जब भी आप कोई relief court से मांगते हैं तो fact of demand कहता है कि आप सच्चाई से सामने क्लैरिटी के साथ कह दो. टेस्टिमोनियल assertions. टेस्टिमोनियल यू नो किसी के बारे में अच्छा बोलना. assertion यानी बहुत फोर्सफुली या फिर with all the conviction you have to tell. The testimonial assertion by the judge created a good air for the petitioner to get the custody of the child. जज ने उसकी इतनी तारीफ कर दी कि नॉर्मली वो पिटिशनर को उसका बच्चा मिलने का चांस ज्यादा है. Created a good air. They created a good air. This is air is also so simple word. Good air is the house